Good morning, Commissioner. Can you hear us okay? Mic check 1, 2. Can you hear us? Mic check 1, 2, 3. Test 1, 2, 3, 4.
Can you hear me?
You sure can. Good morning, Commissioner. Can you hear us now?
Yes, I can hear you now. Thank you.
Awesome. Thank you.
Okay.
Mic check, 1, 2. Good morning, everyone. We should get started here shortly. As a kind reminder for those in the room, if you are registered to speak, please make sure that you are within a close distance of the microphone so that those online can hear you clearly and those in the room can hear you clearly. That goes for those that are at the table as well, to make sure that your microphones are close enough so we can hear you online. When it is your turn to speak, please make sure that the light is on the microphone. You might have to turn it on. And before you leave the podium, go ahead and mute the microphone so that others do not hear outside conversations happening out of your turn.
Good morning and howdy, y'all. I am sorry I am late. In Austin, we can't depend on our power to be on. We can't depend on a lot of different things, but we can always depend on traffic. So with that, apologies. Happy to be here this morning. Before we get started, I wanted to thank our incredible staff for planning the Environmental Excellence Awards that were last Tuesday. It was a phenomenal event. It was my first Environmental Excellence Awards, and the awardees were absolutely incredible humans that have done so much good for the state of Texas, and just a really great event. So, and I think we have the next one in 2 years. Is that right? One? And so next year, take a look. It is an event not to be missed. And with that, welcome to the June 18th, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:43 a.m. I'm joined by my colleagues, Bobby Janecka and Katarina Gonzalez is virtual today, and our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we'll inform the parties and the public of time limits for their discussion. Registration closed at 9:30, but if you would like to address the commission on a particular item, please either visit the registration table if you're here in person. If you're on the webinar, email us at agenda@tcq.texas.gov, their name, affiliation, and item you would like to comment on, and we will do our absolute best to accommodate you. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. And if you are on the interwebs, please keep everything muted until you are about to speak. And with that, Mary, first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Brahman Ranch Municipal Utility District of Ellis and Johnson counties. The parties have been notified that the petitioners, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time. The petitioners should speak first and may reserve a portion of their time for rebuttal as the petitioners bear the burden of proof in this matter. And I believe we have Mr. Ruiz for the petitioners.
Yeah, good morning, Chairwoman, Commission, TCQ staff. James Ruiz here for the petitioners, Miskimo Management 3 LLC and Buffalo Hills Development LLC. And we are here in favor of the adoption of the ALJ's proposed decision, which was for the approval of the application for the creation of the Brahman Ranch Municipal Utility District of Ellis and Johnson counties. The location of the proposed district is just a little south of the city of Venus. The petitioners have entered into a development agreement with the city of Venus that will govern the development of the district if approved, and the district will be providing the wastewater services which are not available from any other means, and also the roads. As the ALJ has come to the findings and conclusions, petitioners have met their burden of proof. The proposed district is feasible, practical, necessary, and will benefit all the land within the district. And with that, unless the commission has any questions, again, we just ask that that be approved.
Thank you. Any questions? Nope. All right, we'll hear from the protestant, please.
Thank you.
Good morning. My name is Stephanie Albright. I'm here with Bickerstaff, Heath, Delgado Acosta, and I represent Ellis County, a protestant in this matter. A MUD is advantageous to a developer by enhancing the value and marketability of the property, and it allows for the reimbursement of costs related to the construction of infrastructure. These costs are reimbursed through taxes assessed on its future residents. The applicant here is not simply asking for permission to draw boundary lines. The applicant is asking to create a new local government entity with the power to levy taxes, to fine its residents, to issue debt, condemn property, and build and finance roads. To be granted the privilege to create a MUD, An applicant should, at the very least, provide a plan of development and projected cost to demonstrate that a proposed project is feasible. The applicant has not done so in this case, and the county asks that you deny the creation of the MUD. The county understands that in a petition seeking to create a MUD, the cost of the proposed development can be estimates that can be adjusted over time. But an applicant must show that a MUD is legally, financially, or technically feasible through the preliminary engineering report, including showing that the costs presented are reasonable to build the development. The applicant in this matter has presented unsubstantiated costs that are underestimated by more than 70%, with water facilities that are undervalued by over $6 million and wastewater facilities that are undervalued by $8.8 million. This significant underestimation of cost with little to no documentation shows that the applicant did not meet its burden under Chapter 54 of the Texas Water Code. The applicant has also not shown that the proposed development will have an unreasonable effect on water quality. The applicant provided no meaningful assessment of the impacts to water quality from wastewater discharge or from stormwater discharge from the development runoff from the proposed development. It is the burden of the applicant to show that the requirements of Texas Water Code Section 54021B are met, and the applicant in this matter has not done so. And for these reasons, the reasons that the county included in its closing arguments and exceptions, the county urges that the commission deny the petition to create Brahman Ranch MUD. And I'm happy to take any questions in my remaining time.
Any questions for Ms. Albright? Nope. We'll hear from the ED.
Thank you.
Good morning, Chairwoman, Commissioners, General Counsel, and Office of Public Interest Counsel. I'm Kayla Murray, and I'm an attorney in the Environmental Law Division, representing the Executive Director. With me today is Justin Tack, Manager of the District Section. The ED recommends the Commission adopt the Administrative Law Judge's proposed order and create the Brahman Ranch MUD of Ellis and Johnson counties. In the proposal for decision, the ALJ concluded that the applicant met its burden of proving the district's creation meets all applicable statutory and regulatory requirements. Therefore, the Commission should grant the petition and create the district. Thank you, and we are available for questions.
Questions for the ED? Nope. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's attorney and staff. For the record, I'm Pranjal Mehta with the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and recommends that the Commission grant the petition for creation of the Brahman Ranch Municipal Utility District. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that the applicants met their burden of proof. As stated in OPIC's closing brief, a preponderance of the evidence demonstrates that the project is feasible, practicable, necessary, and would benefit the land within the proposed district. OPIC agrees with the ALJ's findings that the projected construction cost, tax rates, and water and sewer rates are reasonable. OPIC also concurs with the ALJ's conclusion that the proposed district, its system, and the subsequent development would not have an unreasonable effect on any of the statutory factors outlined in Texas Water Code Section 54.021B3. For these reasons, OPIC respectfully recommends that the Commission adopt the proposal for decision along with the changes recommended in the exception letter and grant the petition for creation of the Brahman Ranch MUD. Thank you, and I'm happy to answer any questions.
Thank you, Pranjal. Any questions for OPIC? Nope. All right, Mr. Rees, you have 3 minutes and 59 seconds left for a rebuttal.
Thank you. And the only thing I think we really need to rebut quickly is the estimates for the construction of the wastewater plant was actually done by an actual bid given by the AUC group. And so to say that it was just, somehow not reasonable is just really ignoring the evidence. In fact, the protestant, the only thing they had was an engineer who just said it was undervalued and provided no numbers whatsoever. And so we have actual bidding from someone who constructs wastewater treatments versus an engineer who got paid $2,500 just to say it's unreasonable. And for that reason, the ALJ found it was reasonable and the application should be approved. Thank you.
Thank you very much. Appreciate your comments. All right, colleagues, item 1 requires us to consider the proposal for decision concerning the petition to create a municipal utility district and the granting of road powers. I agree with how the administrative law judge handled this case and would adopt the ALJ's proposed order with 2 changes recommended in the ALJ's reply to exceptions. I recommend that the commission create the mud and granite road powers, but I note that the administrative law judge did not provide any recommendations concerning the appointment of temporary directors, which the commission is required to do under these circumstances. I believe that the record supports that the proposed 5 temporary directors meet the qualifications and would recommend adding a finding of fact, conclusion of law, and an ordering provision to accomplish the temporary director's appointment. I'll stop right there. Bobby?
I see it the same way you do.
Thank you. Katarina?
I'm in agreement as well.
Do I have a motion?
I would move we adopt the administrative law judge's proposed order with the changes to finding of fact numbers 9 and 27 recommended in the ALJ's reply to exceptions. I further move that we grant the petition for creation of Brahman Ranch Municipal Utility District of Ellis and Johnson counties and the request to acquire road powers. To accomplish this, add to ordering provision number 1 that the request for road powers is granted and appoint the individuals proposed by the applicant and recommended in the ED's technical memorandums to serve as temporary directors until permanent directors are elected and qualified. To accomplish the temporary director appointments, add the following provisions to the proposed order. Finding of fact number 62, applicant submitted affidavits from Abraham Achar, David Moore, Madeline Mitchell, Chigbo Ekweme, and Kayla Caldwell that requested to be temporary directors. No party challenged the qualifications of the 5 individuals to be appointed as temporary directors. Conclusion of law number 19. Based on their affidavits, the 5 individuals requested to be appointed temporary directors qualify for such roles under Texas Water Code Chapter Section 54.022. Ordering provision. Abraham Achar, David Moore, Madeline Mitchell, Chigbo Ekweme, and Kayla Caldwell are named and appointed as temporary directors and shall, as soon as practicable after the date of entry of this order, execute their official bonds and take their official oaths of office. All such bonds shall be approved by the board of directors of the district, and each bond and oath shall be filed with the district and retained in its records.
A second?
All those in favor say aye.
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 The motion passes. Thank you very much. Mary, item 2, please.
Item number, excuse me, item number 2 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of White Oaks Municipal Utility District of Denton County. The parties have been notified that the petitioner will have 8 minutes. Protestants collectively will have 8 minutes, and the ED and OPIC will each have 5 minutes of oral argument time. The petitioner should speak first and may reserve a portion of its time for rebuttal, as the petitioner bears the burden of proof in this matter. And with that, we will begin with counsel for the petitioner, Mr. Moore.
Chairwoman, Commissioners, General Counsel, good morning. My name is Brian Moore. I am here on behalf of the petitioner, White Oaks Ranchland, LP. You have before you this morning a well-reasoned and thorough proposal for decision. So well-reasoned, so thorough, that there were no substantive exceptions to the PFD. And this morning, I have nothing to add to the ALJ's consideration of this matter. Just want to say that we appreciate the Commission's time and consideration of this matter, the ALJ's time and consideration of the case, the ED's review of the application, and the ED's and the Office of Public Interest Counsel's weighing of the issues and analysis of the issues. The parties put great effort and time into this case, and it shows in the proposal for decision. Reserve the remainder of my time, and I'm here for any questions you may have.
Thank you. Any questions for Mr. Moore? All right, we will go to the protestant.
Good morning.
Morning.
Can you all hear me?
Yes.
Guess not. Now you can hear me. Good morning. I'm here. My name is Cody Falk. I'm here on behalf of all of the protestants. We've allocated the time for all of them, but I represent several landowners, but also participating in the case was Denton County Commissioners Court. Good morning, Madam Chair, Commissioners. Thank you for the opportunity to speak today on behalf of the individual protestants who are residents, property owners, and community stakeholders who will be directly and adversely affected by the creation of the proposed White Oaks MUD. We respectfully urge you to reject the ALJ's PFD because it is fundamentally flawed in its findings of fact and legal reasoning. The ALJ concluded the applicant met its burden under 54021, but that conclusion ignores clear statutory standards and relies on assumptions, conjecture, and untested opinions, and therefore does not meet the preponderance of the evidence standard required by law. I'm going to go over several of the items that we addressed in our briefing. First and foremost, the ALJ erred in concluding that the district is necessary. 54021B1 requires the commission to consider whether comparable service is available from other providers. The ALJ found that the project was necessary because the applicant intends to build and then dedicate facilities to Mustang Sud. But that is not necessity. It is convenience for the developer. Mustang Sud already holds a CCN for this area. It has the capacity and legal obligation to serve. Yet the applicant never requested a will serve letter, never executed a service agreement, and presented no evidence in the hearing that it made any effort to secure service through traditional means. Here, not even a scintilla of evidence was presented that the services Mustang Sud is legally required to provide under its CCN are not available. The ALJ accepted vague references to future negotiations and speculative extension policies as evidence of necessity. That is not the legal standard. The statute requires a current lack of available service. There is a CCN, not a lack of convenience or financing options for the developer. The second one that is one of the critical pieces to this case, the ALJ misapplied the law on feasibility and economic assumptions. 54021B2 requires the commission consider reasonableness of the proposed construction costs, tax rates, and utility rates. These that were presented by the applicant were based on an assumption, the assumption that a zoning change was going to be granted. The evidence in this case makes it clear that that assumption is wholly unreasonable. The ALJ found them reasonable even though they're based on a development plan that, as we sit here today, as the application was filed and during the hearing, is not legally permissible under current zoning, and for which zoning and zoning variances would almost certainly be denied. They assume that they will get a zoning change. The evidence in the record completely rejects that concept. Half the land is zoned agricultural under the Lake Ray Roberts Land Use Ordinance. It cannot legally support the high-density development assumed in the petition in the absence of the property being rezoned. The fact that no zoning change or variance has been obtained would not normally be fatal for a MUD application. But here, most notably, the Denton County Commissioners Court, the governing body with the sole authority over rezoning, adopted a resolution to oppose the MUD application, which was passed unanimously. The PFD's conclusion that it was reasonable for the applicant to assume a zoning variance would be granted is in complete contravention of the testimony of Commissioner Ryan Williams that assuming a zoning variance is absolutely unreasonable. This flawed assumption flows through to the rest of the application. By using this assumption, the assessed valuation over $516 million is wildly inflated and speculative. The projected tax base and debt service are completely unrealistic, and the proposed tax rate of $1.20 per hundred valuation assumes development densities that, again, are not legally possible. In short, the financials are based on a development that is a mirage. No legitimate finding of feasibility can rest on such illusory schemes that are infeasible given the development restrictions that were in place at the time of the application, are placed today and are not likely to, yield a way in which and for which an economic analysis has been provided that is based on the density that is legally permissible. They did not provide an alternative to say, well, if we didn't get the zoning change, here's what it would be. There's no evidence in the record of that. The ALJ ignored the lack of evidence on environmental impact. Here, the commission is supposed to consider environmental effects. The applicant offered no studies, no modeling, no site-specific technical evidence to support its claims of no environmental effects, and they were vague and unsupported. The ED then just simply copied and pasted the conclusions and did no confirmatory research as to those conclusions. This is particularly troubling because the development site involves a 100-foot elevation change, planned retaining walls, extensive grading, and a new wastewater treatment facility. A wastewater treatment facility, mind you, that in the proposal from the MUD is located in a zoning district that would not authorize it. In the absence of even a scintilla of evidence to demonstrate the ED evaluated the project's environmental effects, this case would negate the letter of the law requiring such an evaluation. Accepting the ED's conclusory statements about the MUD's environmental impacts or lack thereof not only fails to meet the legal standard of substantial evidence, but clearly violates the statute's requirements to consider environmental effects intended in the creation of a MUD. Lastly, the ALJ failed to properly weigh opposition from the county. Water Code 54061 requires the commission to consider the written opposition from the County Commissioners Court. Here, the Denton County Commissioners Court not only submitted opposition, but did so unanimously. The ALJ gave this no meaningful weight. That directly contradicts the statute and ignores the legitimate authority and expertise of the county in planning and zoning decisions. One piece of note, Mr. Moore mentioned that there were no substantive exceptions filed. I represent landowners that are spending their hard-earned money to fight this case. And when the PFD was issued, they were gutted. And I had to argue and fight to be here today. I'm waiving my fees because this is important. It's not necessary. It's not feasible. It's not lawful under current zoning, and it does not meet the standards under the Texas Water Code requires. We ask you today that what the law demands is reject the ALJ's PFD and deny the petition for the creation of the White Oaks MUD. Thank you for your time, and I'm happy to answer any questions.
Any questions for Mr. Falk?
I believe I caught the figure, $516 million that you mentioned at one point. Could you just clarify what that amount referred to and if I heard the right number or if I misheard that?
Yeah, I could go back to my briefing, but I believe that was the assessed valuation of the property based on the assumption that the density proposed would be authorized.
Perfect. Appreciate that. Thank you.
Katarina, anything? Thank you, Mr. Falk.
Thank you.
Hear from the ED?
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Fernando Salazar Martinez of the Environmental Law Division. With me today is Justin Tack, Manager of the District Section within the Water Supply Division. The Executive Director agrees with the Administrative Law Judge's findings of fact and conclusion of law as referenced in the proposal for decision. After reviewing the evidence in the record, the ALJ found that the applicant met its burden on proof on each of the applicable criteria in Texas Water Code Section 54021B to establish that its petition should be granted. Further, the protestant's pre-filed testimony at the hearing, and closing arguments do not demonstrate that the proposed district will cause any impacts that are not typical for a standard residential development or have any unreasonable effects on the factors listed in Texas Water Code Section 54021B3 A through G. The Executive Director respectfully recommends that the Commission adopt the ALJ's PFD and final order as revised in the ALJ's exception letter dated May 13, 2025, recommending the Commission grant the petition for creation of White Oaks Municipal Utility District of Denton County. And we're here for any questions if you have any.
Questions for the ED? OPIC?
Good morning. Chairwoman, Commissioners, Executive Directors, Attorney, and staff. For the record, I'm Jessica Anderson with the Office of Public Interest Counsel. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that a preponderance of the evidence shows that applicant has met its burden of proof in this matter. OPIC supports the ALJ's recommendation that the commission grant applicant's petition for creation. Protestants argued that applicants' projected construction costs, tax rates, and water and wastewater rates are not reliable because they do not account for the fact that a portion of the proposed district is subject to the Lake Ray Roberts zoning ordinance, and therefore applicants' estimates are not reasonable. However, the ALJ was not persuaded that the ordinance was outcome determinative, and the proposal for decision concluded that the applicant adequately demonstrated the basis for their projected costs and provided evidence about why those costs should be considered reasonable. OPIC is in agreement with this finding. Additionally, in determining whether a proposed MUD is feasible, practicable, necessary, and would be a benefit to the land included in the district, the commission considers whether there would be an unreasonable effect on the following: land elevation subsidence, groundwater levels in the region, recharge capability of a groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land located within a district. The ALJ found that the applicant proved that the proposed district would not have an unreasonable effect on any of these factors, a conclusion that OPIC also found to be supported by the evidence introduced at the hearing. For these reasons, OPIC recommends that the commission adopt the ALJ's proposal for decision and grant this petition for the creation of White Oaks Municipal Utility District. Thank you, and we are available for any questions.
Thank you, Jessica. Any questions for OPIC? All right, Mr. Moore, do you have a rebuttal?
Chairwoman, my only rebuttal is the arguments that you've heard from today from Protestants Council. Well, I strongly suspect that you've read those arguments before, because those arguments had been fully and extensively briefed by the parties in this case. They were considered by the administrative law judge who heard the evidence, who weighed the evidence, and she analyzed those issues and issued her proposal for decision. Again, stand up here and rehash all the arguments that have been put forth in this case. I think that's a good use of our time, and I'll yield the remainder of my time. Thank you.
Thank you. I appreciate that. Well, colleagues, after reviewing the ALJ's proposed order in this matter, I see that there are several mistakes that need to be corrected concerning the creation of the district, including incorrect findings of fact regarding the ownership of the property and total acreage located within the district, incorrect finding of fact on the construction costs, and a total lack of findings of fact, conclusions of law, and ordering provisions regarding the request for road powers and the appointment of temporary directors. Based on the ALJ's PFD, it looks like she referenced a previous version of the preliminary engineering report that was admitted in the record by the applicant and marked as applicant's Exhibit 8. However, the record, including statements by Ms. Scott at the hearing and the references in the closing arguments, indicate that the preliminary engineering report that should have been referenced was the revised preliminary engineering report included in the ED Exhibit JW-4. The parties had ample opportunity to note and recommend corrections to the mistakes in the proposed orders, but failed to file any exceptions to correct these inconsistencies. The petitioner should have ensured that the proposed order creating the district and the preliminary engineering report were consistent. However, I realize that time and resources that would be required to send this back to the LAJ to correct are lengthy, and I'm willing to proceed today by fixing these errors, but I would not be in favor of making it a habit of this, and may be inclined to remand an order like this for corrections the next time. I'm comfortable with the evidence in the record and the commission's authority to make the types of changes that I've discussed today. I have a document with the changes necessary to correct the order. I'll ask General Counsel and the Chief Clerk to distribute these, as well as publish the document in the webinar. Katarina, do you have a copy?
I just emailed it to you, so if you'll check your email.
I'll check it right now. Thank you.
I'll give y'all a minute. Has everyone had a chance to look at the document? Shall we proceed? Commissioners, what are your thoughts?
I'm in agreement with the changes in the document.
Thank you. I'm in agreement as well, and I appreciate your preemptive admonition. I wouldn't want it to become habitual. I recognize and am responsive to the concern that our processes are lengthy and a stop and so is a significant use of resources, cost of resources. I would not want advocates for parties to feel that that is an extra escape valve they could rely on.
Absolutely.
Appreciate your, I'm comfortable moving forward as well.
Thank you. We do not take this authority lightly. Colleagues, I move that we grant the petition for creation of the White Oaks Municipal Utility District of Denton County and the addition of road powers under the Texas Water Code sections 54.234. That we appoint Roberta Matthews Corbett, Elizabeth Marie Brooks, Alashana Vieklong, Cole David Finley, and Tom O'Brien as temporary directors. Adopt the administrative law judge's proposed order with the changes set forth in the document circulated to the commission from the dais today. Is there a second?
I second.
All those in favor?
Aye.
Aye, the motion passes. Thank y'all very much. Give everyone a chance to get settled. Item 3.
Item number 3 is the consideration of the proposal for decision and proposed order concerning the application by Kelly Ranch Estates LLC for new TIPD's permit number WQ 001-637-0001. The parties have been notified that the applicant, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal as the applicant bears the burden of proof in this matter. And so we'll begin with the applicant. We have Mr. Moore again.
Again, good morning. Brian Moore on behalf of the applicant, Kelly Ranch Estates. Again, nothing further to add on this matter. We appreciate the commission's time, the commissioner's time, the ED's time, and OPIC's time. The executive director and OPIC were instrumental in this matter being largely resolved by settlement. Again, appreciate your time and here to answer any questions you may have.
Any questions for Mr. Moore?
For the protestants, we don't have anyone signed in, but this would be an opportunity if there is anybody here representing the protestants or on behalf of the protestants to address the commission.
All right, we will hear from the ED.
Good morning, Chairwoman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Cole Malley with the Environmental Law Division, and I'm here today on behalf of the Executive Director. With me today is Deb Aduta of the Water Quality Division. The ED respectfully recommends that the Commission adopt the ALJ's order and issue the permit. According to Texas Government Code Section 2003-47, protesting parties in contested case hearings may rebut the prima facie demonstration the permit meets all applicable statutory and regulatory requirements. Of the named parties to the hearing, all but one withdrew their protest to the application. Neither the remaining protestants and Mr. King nor OPIC filed any pre-filed testimony. In response, the applicant subsequently filed a motion for summary disposition. After finding that the documents composing the administrative record were properly admitted, that the permit was uncontested, the ALJ granted the motion due to the lack of evidence rebutting the prima facie demonstration and concluded the Commission should issue the draft permit. ED respectfully requests the Commission revise findings of fact number 1 to correct the permit number. It should be WQ 001-637-0001. Thank you. We're available for questions.
Thank you. Any questions for Cole? Nope. OPIC?
Thank you, Chairwoman, Commissioners, General Counsel, ED's attorney and staff. Good morning. For the record, I'm Josiah Mercer with the Office of Public Interest Counsel. We participated in this matter and we conclude that summary disposition was appropriate because no pre-filed testimony or exhibits were filed to rebut the prima facie demonstration provided by the administrative record. On December 3rd, 2024, SOA held a preliminary hearing in this matter in which the administrative record was admitted into evidence. This included the application, the draft permit, and all other materials required to establish the prima facie demonstration under Texas Government Code Section 2003.041471 I1, and 30 TAC Section 80.17C. In January, the applicant reached settlement with all of the named protestants except for Mr. Rusty King. In this settlement, applicant agreed to equip the proposed facility with odor control and chlorination dechlorination systems. They agreed to apply for authorization to use at least some of the treated effluent for irrigation on their property, and they agreed to take and respond to odor complaints in a timely manner. They also agreed to submit a request to the commission to have the odor control and chlorination criteria added as requirements to the permit. Mr. King submitted no filings before the February 3rd deadline for direct testimony and exhibits for the protestants and hasn't filed anything since. At the preliminary hearing, the ALJ explained to the protestants that they would be required to rebut the prima facie demonstration with evidence and written testimony. Additionally, I was in contact with Mr. King via email and phone and shared with him resources from SOA's website on representing oneself. He never suggested to me that he was actively collecting evidence or planning to file anything. And then I attempted to call him last week and didn't get a response. For these reasons, OPIC finds that summary disposition is appropriate because no parties have presented evidence to rebut the prima facie demonstration provided by the administrative record. The proposal for decision is therefore appropriate with the changes suggested by the ED and should be adopted. The permit should be granted, though OPIC recommends that it be granted with the changes agreed to under the settlement agreement. Thank you, and I'm available for any questions.
Well, thank you. And I very much appreciate the additional step you made to call and offer some help with the pro se guidance. That is your job, but I appreciate it very much. Do we have any questions? All right, Mr. Moore, do you have anything?
Chairman, I do not yield my time.
Thank you.
Thank you.
All right, the item before us is an application for a new TIPDs permit. After some of the protestants settled during the SOA process, there was one remaining protestant, Rusty King. After reviewing the record, I agree with the ALJ that the administrative record established the prima facie case that the draft permit meets all legal and technical requirements, and I also agree that no party presented evidence to rebut the prima facie case. Therefore, I am ready to issue the draft permit. Although no party filed exceptions, I would like to propose 3 clerical changes to the ALJ's proposed order. First, I'd correct a typo in the permit number in the finding of fact number 1. Second, I would correct a date in the procedural schedule in finding of fact 20 so that the deadline for the parties to file responses for the motions is identified as March 3rd, 2025. Third, I would correct a statute number in conclusion of Law 3 from Section 5.114 to Section 5.115. Also reviewed the ED's response to comments and propose that we adopt the document. I'll stop here. Bobby?
I'm good with that. Pat?
I'm in agreement as well.
Thank you. Do I have a motion?
I move that we adopt the administrative law judge's proposed order with the following clerical changes. A, in finding of fact 1, correct the permit number to WQ 00163700001. And B, in finding of fact 20, replace February 24th, 2025 with March 3rd, 2025. And C, in conclusion of Law 3, replace 5.114 with 5.115. That we issue the ED's draft permit and that we adopt the ED's response to comments.
I second the motion.
All those in favor say aye.
Aye.
Motion passes. Thank you, Cole. Thank you, Josiah. Mary, item 4, please.
Item number 4 is the consideration of an application by Coupland Utilities LLC and Land Crowd Developers LLC for new TIPDs permit number WQ00164460001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. We have an application before us for a new TIPDs permit that would discharge up to 200,000 gallons per day of treated domestic wastewater. For these types of applications, the commission considers a two-step analysis. First, we determine whether a hearing requester is an affected person. If there are affected hearing requesters, then we consider whether an affected person raised issues in their hearing that requests that are referable to our friends at SOA. The commission received timely hearing requests from the Jonah Water Special Utility District and Julie Van Zant. To be considered an affected person, the requester must explain how they will be affected by the application in a way that is not common for the members of the general public. The hearing requester must also file both timely comments and a hearing request that identify both their personal interest and the concerns that they have. Finally, the identified concerns must be within the commission's jurisdiction to address in the authorization. I believe that both hearing requesters meet the procedural and substantive requirements for a hearing. Jonah Water SUD holds a water CCN for the territory that this discharge passes through. Jonah raised concerns related to the discharge effect on the water quality of its drinking water sources, which it states are within close proximity to the discharge. And Ms. Van Zant resides in close proximity to the facility and along the discharge route. She raised relevant and material concerns regarding water quality and the discharge effect on her health and safety. So I would grant their requests. I'll pause here. Bobby and Katerina?
I'm in agreement.
I'm also in agreement.
Let's move to the second part of our analysis on issues. As I mentioned, both requesters raised numerous relevant and material issues, including water quality, whether the application was accurate, monitoring and reporting requirements, nuisance, odor, compliance history, regionalization, and discharge route characterization. All of these issues are relevant and material issues that are appropriate for SOA referral. Pause.
I agree.
I also agree.
Finally, given the number of issues, I believe the 180-day hearing duration is appropriate. Any thoughts?
I'm in agreement. I could provide a motion.
Great.
I move that we grant the hearing requests of Jonah Water Special Utility District and Julie Van Zant, deny all requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues. Issue A, whether the draft permit is adequately protective of water quality, the requesters and her family's health, aquatic life and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue B, whether the application is accurate and substantially complete and provides sufficient notice in accordance with applicable notice requirements. Issue C, whether the draft permit contains adequate monitoring and reporting requirements, including adequate licensing and operational requirements for the facility. Issue D, whether the draft permit adequately addresses nuisance odors in accordance with applicable requirements, including 30 Texas Administrative Code, Section 309.13. Issue E, whether the draft permit should be altered or denied based on applicant's compliance history. Issue F, whether the draft permit complies with TCQ's regionalization policy, including demonstration of need in accordance with Texas Water Code, Section 26.0282. And issue G, whether the proposed discharge route is adequately characterized in accordance with 30 Texas Administrative Code, Section 309.12. Finally, move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second?
All those in favor say aye.
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 Motion passes. Thank y'all very much. Item 5.
Item 5 is the consideration of the petition filed by Bisonet 136 LLC for the creation of Harris County Municipal Utility District number 584. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. The item before us is a petition to create a municipal utility district with road powers. Harris County is the sole hearing requester. For district creation matters, we look only at whether the hearing requester is entitled to a hearing. For this item, TCEQ rules require the commission to consider for governmental entities their statutory authority over or interest in the issues relevant in the application. Harris County raised its statutory authority over an interest relevant to the application, including its environmental enforcement authority related to water quality and runoff within its jurisdiction. The county also raised its interest in ensuring compliance with the municipal stormwater permit collection system for which it is the co-permittee. The county asserts that the stormwater from the district would run off into this collection system and raises concerns related to water quality and runoff, including concerns related to whether the costs are adequate to ensure that water quality, given the location of the development on the two closed landfills. Therefore, I agree with the ED and OPIC's recommendation that Harris County is an affected person and this matter be referred to SOA. I'd also recommend that this matter be referred to the Commission's ADR program to run concurrently with the SOA scheduling process. I'll pause here. Bobby and Katarina.
I agree. Harris County demonstrated several reasons that they are qualify as an unaffected party, and I agree with you.
I agree. I do have some thoughts, though. I did find this odd because the city created to the district, consented to the district creation, but the county's protesting. But I don't think that that negates the county's statutory interest in this matter. I also, I find it a little odd too that I think that we're going to go through this SOA process and there be no change in the outcome because I think these landfill concerns are going to be addressed in a separate matter. But I don't think that that excludes the county as an affected party for this matter. So ultimately, I agree with the ED and OPIC that Harris County is an affected party given their interest in the issues raised, particularly regarding runoff drainage, water quality, and its impacts to the MS4 permit. So I am in agreement, but a little troubled by the process.
Very insightful comments. Katarina, anything?
Well said.
Do I have a motion?
I move that we grant the hearing request of Harris County, refer the matter to SOA for a contested case hearing on the petition, and refer this matter to the Commission's Alternative Dispute Resolution Program concurrently with the SOA preliminary hearing scheduling process.
I second the motion.
All those in favor say aye.
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 The motion passes. Thank you. Thank y'all. Move on to item 6.
Item number 6 is the consideration of the application by Rainbow's End Park Incorporated for new TIPD's permit number WQ00165130001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Good morning. Before us for our consideration is an application by Rainbow's End Park Incorporated for new TIPD's permit to authorize a wastewater discharge of 60,000 gallons per day in its final phase. We received one hearing request from Mr. Larry Redden, raising concerns about the impacts of the proposed facility on his and his family's health and property, as well as impacts to animal life and water quality, including his drinking water wells. In my review of Mr. Redden's hearing request and the responses, including the executive director's map indicating that the discharge route crosses Mr. Redden's property, I believe that he has demonstrated effectiveness in this matter. So I'd grant Mr. Redden's hearing request and refer 2 issues to SOA. The first concerning potential impacts to health, property, and wildlife, and the second issue concerning surface and groundwater quality impacts. I'd also include a 180-day hearing duration and concurrent referral to the ADR program. I'll pause. Bobby?
I reached a consistent point in my analysis.
I'm in agreement as well.
Thank you. Do I have a motion?
I move that we grant the hearing request of Larry Redden, refer the application to SOA for a contested case hearing on the following issues with a concurrent referral to the TCQ's Alternative Dispute Resolution Program. Issue A, whether the draft permit is protective of the requesters and his family's health and use of property, wildlife, and livestock in accordance with applicable regulations, including the 30 Texas Administrative Code, Chapter 307, Texas Surface Water Quality Standards. And issue B, whether the draft permit is protective of water quality, including the protection of surface and groundwater, in accordance with applicable regulations, including the Texas Administrative Code, Chapter 307, Texas Surface Water Quality Standards. Finally, move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
A second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank y'all. We'll move on to item 7.
Item number 7 is the consideration for adoption of the new air quality standard permit for temporary concrete batch plants supporting public works projects. The executive director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Michael Wilhoit with the Air Permits Division. With me is Amy Browning of the Environmental Law Division. Attending virtually is Terry Salem of the Environmental Law Division. Also available for questions is Sam Short, Deputy Director of the Air Permits Division, and Bonnie Everidge, Manager of the Mechanical and Coatings Permits Section. For your consideration today is the issuance of a new non-rule air quality standard permit for temporary public works projects authorized under Texas Health and Safety Code, Section 382.051985, standard permit for certain temporary concrete plants for public works. And Title 30 Texas Administrative Code, Chapter 116, Subchapter F, standard permits. Senate Bill 1397, 88th session, amended Chapter 382 of the Texas Health and Safety Code to require that TCQ issue a standard permit for temporary concrete batch plants that support public works projects. Notice of the proposed standard permit was published in the November 1, 2024 issue of the Texas Register. A public meeting was held on December 6, 2024, and the public comment period ended at midnight on December 6, 2024. The rule team received a wide range of public comments. In response, several changes have been made to the standard permit being considered for issuance. The standard permit has been revised to allow a daily production limit as an alternative to restricting operations to 12 hours in any 24-hour period. The standard permit has also been revised to allow paving with a hard, cohesive surface as another method for controlling dust emissions from roads and traffic areas. Requirements associated with stationary engines have been removed from the standard permit, and the proposed requirement for a registration fee has also been removed. In conclusion, staff respectfully recommends issuance of this new air quality standard permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register publication requirements. Thank you. We're available to answer any questions.
Thank you very much, Michael. Any questions for the ED? Mary, do we have anyone signed in on this item?
No one has signed in on this one.
OPIC?
Yes. Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, Attorney, and staff. For the record, I'm Sheldon Wayne on behalf of OPIC. Our office participated in and supports adoption of this non-rule air quality standard permit for temporary concrete batch plants to support public works projects. The creation of the standard permit is necessary to properly implement recent legislation, and we note that the Commission has conducted a protectiveness review demonstrating that the standard permit is protective of human health and welfare, and that facilities operating under its conditions will comply with TCQ rules and regulations. Additionally, OPIC recognizes that the Executive Director duly considered all public comments received and made changes that are appropriate and defensible, and most importantly, continue to ensure that the permit is protective of human health and the environment. Therefore, OPIC supports adoption as recommended by the Executive Director. Finally, we commend the Executive Director's staff for the hard work that went into the development of this permit. Thank you, and I'm available for any questions.
Thank you. Any questions for Sheldon? All right, colleagues, after reviewing the backup materials and the numerous comments provided in this matter, I agree with the ED that this new standard permit approximately implements legislative and statutory changes that allow for the creation of a standard permit for temporary public work projects. Air quality analysis performed by the ED staff demonstrates that the standard permit is protective of public health and the environment. I also believe that the standard permit complies with all statutory and regulatory requirements, and the ED adequately responded to all comments submitted during the comment period. So I'd support the adoption of this new standard permit.
I agree. I want to just thank and acknowledge the extensive engagement and involvement from the public in providing comments on this proposal, but also the significant amount of work that staff undertook reviewing and responding to thoughtfully. I think many of the different concerns that are addressed sufficiently in our agency's analysis or our enforcement posture over these facilities.
Well said. Commissioner Gonzalez.
I also appreciate the work of the staff. I know a lot goes into these, so I move that we adopt the air quality standard permit for temporary public works projects as recommended by the Executive Director and issue the Executive Director's proposed order.
Do I have a second?
I second.
All those in favor say aye.
Aye.
The motion passes. Thank you. Item number 8, please.
Item number 8 is the consideration of gifts and donations of $500 or more in value given to the TCEQ submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. The Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations the agency has received in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully request your acknowledgement of these items. As always, I'm available to answer any questions you may have regarding these items.
Thank you. Any questions for Yen? Nope. Has anyone signed in on this item?
No one signed in on this one.
OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm the Senior Attorney for the Office of Public Interest Counsel and Acting Director while Mr. Arthur is away. OPIC has reviewed the resolution acknowledging acceptance of gifts and donation and supports approval as presented by the Executive Director.
Wonderful. Thank you very much. I'd like to thank the organizations that made these donations so that our agency staff could present at conferences and attend these meetings, trainings, and workshops. I'm prepared to move forward with approving the issuance of the resolution acknowledging the donations. Commissioners?
I move that we approve issuance of a resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCQ Interoffice Memorandum to the Commissioners filed in docket number 2025-0577-MIS.
Do I have a second?
A second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Thank you again. Let's go through our enforcement docket, items 9 through 19.
That does take us to enforcement, 9 through 19, and the Executive Director's staff is here to present.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sotomayor of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 19. the total assessed administrative penalties are $243,590, with $62,842 deferred, $11,998 applied towards supplemental environmental projects, and $168,750 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Smith. Do we have anyone signed in on these items?
We do. We have people signed in on items 13 and 17 who have asked to address the commission. We can begin with number 13, Amy Gardenshire. She's virtual.
Ms. Gardenshire? Amy, are you available?
So I'm receiving a message that she's not online. So we'll go on to the next person on my list, number 17, Silas Jonas.
Mr. Jonas? Silas Jonas, are you available?
Yeah, I'm available.
How do you have a comment for the commission?
Yeah, hi. Thanks for hearing me today. Have you, are you all familiar with the case at hand that we're talking about?
Yes, sir.
Okay. Yeah, so we purchased this, got a little bamboozled by the people that were selling it to us, didn't realize that there was a bad nitrate issue in the water well. Anyway, we've owned the property for some time and we have discovered that the nitrate issue is high, and we are applying for funding with the Texas Water Development Board to potentially help mitigate some of those costs. However, in regard to our enforcement action, in Lubbock, Texas, and East Lubbock, the city of Lubbock has discharged their wastewater for decades into that groundwater, and it's increased the nitrate levels. And all of the water in that part of the county has high nitrate levels. Our nitrate levels are above the MCL allowed by the state. And the comment is that the city of Lubbock has caused the nitrate problem. It's generally accepted based on my experience in the industry. And my question, I don't know if I'm allowed to ask question, but my question would be, is the city of Lubbock helping public water systems mitigate or treat this high nitrate level? Because that's something that's been caused by their discharge that's happened over the decades. Because it's a significant issue, and our neighbors who are under the requirements of a PWS are consuming the high nitrate water and unknowingly ingesting it in many cases, we believe. But in our case, we have to treat for it and remove it. And I'm just wondering if the city of Lubbock, if the TCEQ has ever brought it up to them that they need to help people like us because they caused that problem.
I appreciate your question. I think it's better suited to the ED staff, probably offline. If you could contact them after this hearing, I'm sure Amy would be more than happy to help you.
Yes, we'll make sure we follow up with him.
Thank you.
Is there an opportunity for the TCEQ commission to waive the fees associated with this? Is that a possibility?
No, sir, it is not at this time.
Okay.
I would like to
Yeah.
note that this particular order does have the 100% deferral attached to it for the naturally occurring constituents, because we recognize that issue here. So
Would you speak up and repeat that again, Amy?
yes, ma'am. I just wanted to make a note on the record that this one does have the 100% deferral of the penalty for the naturally occurring constituents.
Yes.
And so we can make sure we communicate back with the respondent and that he's clear on this matter.
Excellent.
Yes, that would be helpful. Okay, well, thank you all for your time. Have a good day.
Thank you. Appreciate you. OPIC?
Good morning again, Chairwoman Eli Martinez with the Office of Public Interest Counsel. For the record, we've reviewed these items, their proposed penalties, any comments submitted by the respondents, compliance histories, adherence to the penalty policy, and notice and other procedural requirements. And at this time, we are satisfied these items do in fact comply with the relevant statutes, rules, and policies of the Commission, and OPIC is therefore prepared to support the adoption of the proposed enforcement orders listed in items 9 through 19 of today's Commission agenda.
Thank you very much. I'd like to thank staff for their work to bring these items before us today. I reviewed them all and I'm ready to move forward. Commissioners?
I'm also comfortable moving forward the docket today. I just want to thank the comment we received from Mr. Jonas. I appreciate the our staff's point. We do waive those direct penalties associated with that, but I acknowledge that there's a treatment cost and there is a burden borne by all those residents of that part of our state. So I would be curious myself to follow up on that thread as well, to explore what connections we may be able to support from a regulatory perspective and where we may recognize the technical connections, but there is a legal impediment in some way, form, just to make sure that y'all understand. I would like to be well aware of where our agency's powers are constrained or supported by existing law in this space. So thank you for raising this comment today.
Commissioner
I
Gonzalez?
move that we adopt items 9 through 19 as recommended today by the Executive Director.
Do I have a second?
I second the motion.
All those in favor say aye.
Aye.
Thank you. The motion passes. Move on to number 20, please.
Item number 20 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present this matter.
Good morning again, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Michael Parrish of the Enforcement Division and Katanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through April. There were 698 effective administrative orders issued, and of these, 66 contained supplemental environmental projects. These orders assessed a total of $9,401,557 with a payable amount of $6,034,035. $2,057,858 are to be paid towards supplemental environmental projects. 13,178 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,166 enforcement action referrals have been received. There are 3,156 pending administrative orders with 1,445 cases that are on the backlog. 136 cases are pending at the Attorney General's office for representation in district court, and 6 judgments have been issued. 1,509 cases are being tracked for compliance. We're available to answer any questions you have.
Amy, how many cases do we have at OAG at this moment?
We have 136 currently pending at OAG.
136. Thank you. Any questions?
I was curious on the last 2 report intervals. For the first figure, I provide numbers to support the number of notices of violation. Does that represent a pat on the back to staff getting a tremendous workload processed concurrently with the demands of legislative session, or does that represent an uptick, a necessary increase because there was such an uptick in the world of cases we're dealing with?
Probably a little bit of both, but I don't have a specific correlation with what, but I suspect there's a little bit of both in that. Yeah.
I appreciate hearing that. I just can't help but notice that and not find a little curiosity about digging deeper into that story. But I do acknowledge it represents tremendous effort, ongoing effort on the part of our staff to continue to carry difficult circumstances that our regulated entities and the public around them face in terms of compliance, getting quickly back into compliance, and just appreciate all the work that gets captured and simplified into a few colorful little graphs.
Commissioner Gonzalez, anything?
No, thank you.
Thank you. Thanks staff very much for the report. OPIC, I'm sorry.
Good morning again. No comments on the report, Chairwoman, though we do, as always, appreciate the efforts it represents to ensure that The protections afforded by our rules and the permitting provisions we apply to our permits and authorizations for public health and the environment have been appropriately adhered to.
Thank you so much. As Bobby so noted, our core mission does not slow or delay during session. We are expected to do both beautifully, and we do. We're a compliance first agency, and I very much appreciate this report. Anything else to add? No action is required on this item. Let's go to the next item, 21, please.
Item 21 is the consideration of the adoption of new 30 Texas Administrative Code, Chapter 353, Leaking Water Wells Grant Program. And the Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. I am Cindy Hooper with the Water Availability Division, and with me today is Stephanie Escobar with the Water Availability Division and Kayla Murray with the Environmental Law Division. The rulemaking adoption before you will create new 30 TAC Chapter 353 and establish the Leaking Water Wells Grant Program. The rule implements House Bill 4256 of the 88th Texas Legislature's regular session in 2023. The legislation added Subchapter E to Chapter 28 of the Water Code. It specified who the program applies to, and it described which projects are eligible to receive grants. HB 4256 requires TCEQ to create and administer the grant program, develop criteria to prioritize projects, provide grants to eligible groundwater conservation districts or GCDs, and establish standards to ensure that wells in the program are permanently plugged. The criteria in the rule adoption to prioritize projects includes well characteristics, well location relative to sensitive areas, environmental issues, well site safety and access considerations, economic factors, and other priorities determined by the Commission. The rule adoption includes criteria to ensure a well is permanently plugged, and these criteria were established in consultation with the Railroad Commission of Texas. The proposed rule was published in the January 3rd, 2025 issue of the Texas Register. A public hearing was held on January 29th, and the public comment period closed on February 4th. The Commission received comments from one eligible groundwater conservation district and from 6 individuals. All comments were in support of the rulemaking. The GCD in their comment letter requested a definition for leaking water well, as well as information on eligible expenses and the timing of grant fund disbursement. Staff responded to each comment, and while the comments did not result in changes to the rule language, staff did note that many details would be further addressed in the grant documents, which are being developed separate from the rulemaking. To that end, an informational workshop on the grant program was held on May 20th, in which all GCDs were invited. During the workshop, staff provided information on the grant program and offered an opportunity for questions and feedback. Staff are currently developing the mechanism by which we will distribute grant funds after the rule adoption. In conclusion, we respectfully recommend adoption of new 30 TAC Chapter 353 and also request permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you, and we're available for questions.
Thank you, Cindy. Any information on the timeline regarding the availability of those grant funds? I know the 89th provided $10 million in the latest budget.
Right, I think the numbers are right, maybe 9.5 or something, but I think, so we are working to be able to have applications available in the fall and funds available, I think by fiscal 26. Is that right? Yeah, that's correct.
Excellent. Well, my travels as chairwoman of the Water Development Board, I've seen several of these leaky water wells, and they are striking is the only way to describe them. So happy to see this legislation move forward and this world move forward. Any thoughts or comments?
I'm glad to see us making forward progress on this rulemaking. I just can't help but note how concerned I am to see some of the staff from one of the parts of our agency that I know is already desperately overtaxed and over asked by many of the needs our state is facing in regards to water and water availability and the disproportionate need of hydrology as a skill set in that part of our agency. I recognize from working in past years in the underground injection control or adjacent to the underground injection control program in our agency, how interconnected all of that really is. And so I'm grateful to see us making forward progress on plugging these wells. I'm hopeful that as we shift into the grant function for this need in responding to this mission the legislature has given us, that we are able to contain the technical burden that spills out and puts on our staff. I think those are highly qualified, highly skilled individuals who come and do their service to the state in a very fulfilling, very interesting place to find a lot of problems that meet Texans' needs. But man, it's a thankless grind. So I'm eager and also a little wary about what new problems we'll discover in stepping into this space. But I'm grateful to the legislature for continuing to respond to the need. I don't doubt that they will heed our call if we come back and say we're going to need something a little bit different or more. This is definitely going to be a growing need that I don't expect that the limited groundwater districts that currently can participate in this program will be a complete and final list over the total life of this program. So I'll name that as well and shut up here. Thank you very much for the chance to chime in on it.
I never want you to shut up. No one has ever told you to shut up, and I never will. Yes, I agree with you. I don't think this is thankless though, because this is a significant public health concern. So allowing TCEQ the authority to go out and try to remedy these leaky water wells, that is good for the state of Texas. And I am very thankful for y'all, and I know the citizens will be too. And I do see this as a phased approach. The legislature usually does it that way. So we will see how it goes with these conservation districts and this, I guess, starting of 9.5. Is that what you said? I thought it was 10, but
I think it was 10. We were appropriated some funds this current fiscal year to hire staff and to get the program started. So I think some of that might have been taken on.
Wonderful. Well, I'm very interested to see in the fall where these funds go and how they do help the state. And then next session, we can report back on the progress or on the difficulties and move forward. But I think it is a very important public health concern, and I'm very grateful that you all are tackling it for us. Thank you. Do we have anyone signed in on this item?
No, we don't have anyone signed in.
Katarina, did you have any comments? Yes.
Yeah, I just want to echo Commissioner Janeka's comments. I appreciate those, but also thank the staff for their work on this, and especially in staying true to the legislation. I've mentioned this several times from the dais, and I really appreciate that when the staff does that. Thank you.
Thank you, Commissioner Opick.
Good morning. Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. Again, for the record, I'm Jessica Anderson on behalf of OPIC. OPIC has reviewed this proposal for rulemaking and respectfully recommends adoption. Texas Water Code, Chapter 28, Subchapter E requires TCEQ to establish and administer a leaking water wells grant program, and for the Commission to establish by rule criteria for prioritizing projects eligible to receive a grant under the program. OPIC notes that members of the public would benefit from the cessation of surface and groundwater contamination that is associated with leaking water wells. And OPIC further notes that the agency received comments from members of the public, including 6 individuals in Middle Pecos Groundwater Conservation District, and these commenters were all in support of this rulemaking. Thank you, and I'm available for any questions.
Any questions for OPIC? Nope. Colleagues, this item would create the new Chapter 353 in our rules and would implement the Leaking Water Wells Grant Program in accordance with HB 4256 from the 88th legislative session. I want to acknowledge staff's work on this rulemaking and note their communication with GCDs about the program's implementation, including during a recent workshop in May. In my view, the rules adoption is consistent with HB 4256, and I'm ready to move forward with adoption.
I move that we adopt new 30 Texas Administrative Code Chapter 353, leaking water wells grant program, as recommended by the Executive Director.
Do I have a second? All those in favor say aye.
Aye.
Thank you. Motion passes.
Thank you.
All right, items 22 to 25, executive sessions.
So the commission will be meeting in closed session today in room CR 246 of the Texas Workforce Commission at 11:15.
11:15.
11:15 is permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items numbered 22 through 25 as posted and noticed.
This meeting stands in recess.
PCEQ, Office of the Chief Clerk. This is Ellie. Okay. Does the document have a TCEQ docket number or a permit number that I might be able to reference? Okay, and ready when you are, sir.
The commission met in room 246 of the Texas Workforce Commission for closed session from 11:18 until 11:38 a.m. on item numbers 22, 23, and 25 as posted and noticed pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned and the time is 11:43.